The question is that this bill be now read a second time. I call the member for Bradfield.
Thank you, Mr Deputy Speaker. I rise to speak on the National Consumer Credit Protection Amendment, Home Loans and Credit Cards Bill, and in doing so I observe that there is nothing that gladdens the heart of the Rudd-Gillard government more than a piece of detailed, prescriptive, intrusive micro-regulation seeking to get its fingers deep into the entrails of the day-to-day conduct of business. There is nothing that gladdens the heart of the Rudd-Gillard government more than a cartoonish headline political attack on the business sector and, in this case, the banking sector. And there appears to be, I regret to note, Mr Deputy Speaker, nothing that gladdens the heart of the Rudd-Gillard government more than rushing out legislation in a furious burst of enthusiasm well before the actual critical detail as to how the arrangements are going to work has in fact been sorted out. Isn't that all too familiar a pattern with this government, Mr Deputy Speaker? And with this bill that is before the House this evening, I regret to note that we have once again seen this pattern at play. Mr Deputy Speaker, let us be clear here. The question is not whether some Australians are offered credit card increases which they are ill-equipped to deal with. Of course that happens all too often. The question is not whether there are issues in terms of people dealing with credit who may not be well-equipped to deal with it. The question before this House is whether this particular bill is an effective way of dealing with the problem, because this government, Mr Deputy Speaker, assumes consistently that all you need is good intentions. All you need is good intentions. If you genuinely think there's a problem, then bring forward any measure, any package, and that ought to be judged as a success. The real question for the House, Mr Deputy Speaker, is whether, as a matter of fact, this is an effective and sensible package of measures. And I regret to say that there are serious reasons to doubt that it is an effective and sensible package of measures. I note that the genesis for this legislation was a deeply political exercise, a package of so-called reforms announced on the 15th of August 2010, a date you will have no hesitation in recalling, Mr Deputy Speaker, which fell during the middle of the last election campaign. Substantively, there are some 6 measures contained in this package which this bill now seeks to pass into law, and some, as we have been pleased to acknowledge, have some merit. Others, I regret to say, have very little merit and could fairly be described as merely being meretricious window dressing designed to pad out a press release. I seek to make 3 points, Mr Deputy Speaker, in the time available to me this evening. Firstly, to too great an extent, this bill gives effect to a package of measures driven largely by politics, not by policy, and by a political desire to have a package on credit cards. Secondly, Mr Deputy Speaker, much of this bill involves detailed, onerous and poorly thought-through regulation, the costs of which look very likely to considerably exceed the benefits. The third point I wish to make, Mr Deputy Speaker, is that the implementation of this package, regrettably, has been done in this government's usual shoddy, hasty and imprecise way, and indeed much of the critical detail is still not yet available because it is contained in regulations. Let me turn to the first point, Mr Deputy Speaker. This is a package driven largely by politics, not by policy. Let me quote some of the more fragrant observations from the press release issued by the Treasurer on the 12th of December 2010. According to the Treasurer, this package of measures headed a competitive and sustainable banking system, of which the measures in this bill form part, will, quotes, give every Australian a fairer go, close quotes. I note parenthetically that he seems to be troubled by self-doubt because he's not committing to a fair go, merely a fairer go. He goes on to say, in another typical flourish of rhetoric, that we, quotes, won't let the big banks off the hook, full stop, close quotes. And if there was ever a clear indicator of the deliberate political intent of this legislation, I think that quote gives the game away. Again, a little bit of self-doubt from the Treasurer, who goes on to note, quotes, "There's no silver bullet here," close quotes, which might as well amount to an admission that quite a number of the measures in this bill are frankly more trouble than they're worth. The costs they will introduce exceed the benefits. But he nevertheless commits to, quotes, "keep working hard to give all Australians a fighting chance." And again, I wonder how giving Australians a fighting chance measures up to the standard he set himself at the start of the press release to give every Australian a fairer go. But the thing that really stands out, Mr Deputy Speaker, is a classic non sequitur. We've come to appreciate the non sequitur as the favourite rhetorical device of the Treasurer of Australia, and there's a fine example of a non sequitur in this press release, because immediately after these statements that I've quoted, he goes on to say, quote, "vigorous competition is the best way to keep interest rates for borrowers lower over time and create a system that offers real choice." And I'm very pleased to say, Mr Deputy Speaker, that I agree with that proposition. On this side of the House, we very much agree with the proposition that vigorous competition in the banking sector, as in every sector, is very much to be encouraged. But we do ask ourselves the question, how much credibility does this Treasurer have about calling for vigorous competition in the banking sector when, on his watch, there were not one but two very significant bank mergers waved through? St George and Westpac were allowed to merge, and the Commonwealth Bank and Bank West were allowed to merge, in both cases approved by the Treasurer of Australia, the same man under whose watch this particular piece of legislation is being brought forward. The Assistant Governor of the Reserve Bank of Australia, Mr Guy Debelle, noted in a speech last year that as a result of those two mergers, the major banks' combined market share rose from 60% to over 80% between 2007 and 2009. The reality is that this Treasurer, this government, this Rudd-Gillard Labor government has presided over one of the most dramatic contractions of competition in the banking sector that we have seen for a very long time. And you don't make up for a significant attack on competition, as this government has been party to, by putting in some worthy sentences into a press release. I'd suggest to you, Mr Deputy Speaker, that what this government is trying to do with this particular package of measures, these detailed controls on credit cards, is to seek to make up for the fact that, in reality, competition in the banking sector is considerably weaker than it used to be. If we look at what some of these measures are, Mr Deputy Speaker, they include prescribing rules for approval of the use of credit cards above a credit limit, restricting credit providers from making unsolicited invitations to borrowers to increase the credit limit of their credit card, and introducing a requirement for lenders to put out a key fact sheet for credit card contracts. Well, Mr Deputy Speaker, I want to make the point that much of this package of measures involves detailed, onerous and poorly thought through regulation, the costs of which can be expected to exceed the benefits. Let me take, for example, the very broad prohibition against written communications to customers regarding a credit limit increase under the proposed section 133BE. Now, this will not only apply to express offers and invitations, to use the legal language, but it also has, in practical terms, the effect of capturing any communication to a customer that has the purpose of encouraging the customer to consider applying for an increase. It is very broadly drafted indeed, and is likely to prevent communications which are not only not objectionable but are highly desirable. A further question which is raised about the merits of the measures contained in this legislation is to ask why it is necessary, in light of the fact that there is already a very tight regulatory regime dealing with credit limit approvals under Chapter 3 of the National Consumer Credit Protection Act. A further question, Mr Deputy Speaker, which might be asked is, isn't there a risk that by imposing detailed restrictions on the capacity of banks to offer increased credit limits to their customers, that they will in fact be incented to start by offering higher credit limits than they might otherwise have proposed? Isn't there a real possibility that this legislation will end up having the very opposite effect from the one which is proposed? Of course, another serious concern with this package of measures, Mr Deputy Speaker, is that some of the critical detail is not obvious on the face of the legislation, because the legislation simply provides that there will be regulations made regarding these matters. For example, the key provision to be added to the National Credit Code, section 30 capital B, which gives the Minister the power to make regulations regarding interest charges. A further question which might very reasonably be asked, Mr Deputy Speaker, is why is it the case that this legislation is rife with strict liability provisions? That is to say, provisions under which guilt is simply assumed. The mental state of the person charged with the offence is considered to be irrelevant. Well, one answer why it might be rife is that such provisions appear to be rife in every piece of legislation this government brings forward, because they sit very well with this government's preference for detailed, prescriptive and intrusive regulation. But it is a very good policy question. I note some of those provisions have been removed in the set of amendments which have been put forward by the government at the 11th hour, but we still face a very serious and obvious question. Why is it that there are simply so many measures contained in this bill which seek to impose strict liability? The third point I wish to make, Mr Deputy Speaker, is to note with considerable regret that the implementation of this package has been done in a shoddy, hasty and imprecise way. The exposure draft was released on the 3rd of March, and only 2 working days were allowed for written submissions to be received by Treasury, even though this bill deals with extremely complex business processes involving the provision of services to millions of Australians, and the practical day-to-day management consequences of this sweeping set of changes are very, very substantial. I note further, Mr Deputy Speaker, that when the bill was first introduced, there were a set of provisions which guaranteed or mandated that every customer of a bank would be automatically provided with a 10% buffer facility. That's to say, in practical terms, their credit limit would turn out to be 10% higher than they had understood it to be and their bank had understood it to be. Now, it was pointed out to the government that that wasn't a particularly good idea in a piece of legislation which is supposed to prevent the automatic or the unsolicited increase in credit card limits, because it has the substantive effect that you effectively give every customer a one-time 10% increase in their credit limit. It's hard to think of a clearer example of the very shoddy way in which this set of rapidly rammed together measures, dreamt up for political purposes, has been sought to be reduced to legislation. I note that as a consequence of this rather obvious point being made to the government has, at a very late stage, chosen to completely remove the provisions that were in the original bill dealing with this buffer mechanism, and has introduced a whole new set of provisions in this area by means of amendment. And I suppose we ought to at least acknowledge the fact that the government has conceded the self-evident logical problem in the original set of measures dealing with these this so-called buffer facility. In substance, Mr Deputy Speaker, what we have here is a piece of legislation which contains 1 or 2 sensible measures and a range of other measures which are difficult to justify, a set of measures which have been thrown together quickly to meet a political imperative to have a package on credit card and a package on banking which could be taken to the 2010 election. We then have a set of measures contained in this legislation which have been drafted in haste, which deal with very complex business processes affecting millions of people, very, very expensive to organise and administer, and yet these have been put to the banking industry with quite inadequate time for consultation, and we subsequently find ourselves considering a piece of legislation which contains some significant drafting errors, some significant problems of logic, and in some cases the original premise of which has been almost completely changed by late-in-the-day amendments. Mr Deputy Speaker, the key principle is this: a government needs more than good intentions, it needs detailed, well-worked-through policy.
Order.